Hello, hi. Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. I welcome you. Hope you're fine. Hope you're good. Hope you're doing well. So today we are looking at techniques in cross-examination. What are the techniques of cross-examination? If you're yet to subscribe to the channel, please do hit the subscribe button. Share the video, comment if you have questions. This is an interesting and a beautiful family lawyers info hub. We welcome you to join our fold. We are passionate about the growth of legal education, and we believe that everyone who is a lawyer, who is a law student, who is interested in law should be excellent in their legal knowledge, should be excellent in what they do, should be excellent in their approach, should be excellent in their work. I know knowledge is like light, eradicates ignorance, eradicates, you know, uh, uh, you know, yes, ignorance of what lack of knowledge. Let's put it at that. So I believe that what we're going to learn today will help you when you are to cross-examine a witness, or when you are to lead somebody, or when the party or the lawyer on the other side of a case questions a witness who is not his own witness. So during trial, there are three stages in trial. We have the examination in chief. This is when the party who called the witness, asks questions, you know, to prove their case. After that, the court will call on the party on the other side to cross-examine, to ask questions to that particular witness. After which, that's what we call the re-examination. If there are ambiguities, if there are new issues raised during the cross-examination, the party who called the witness is at liberty to also, you know, ask questions to that witness to clarify those ambiguities or new issues raised. Now, our core of today's class, the core of the class is to look at the techniques. What are the techniques I can employ to have a good cross-examination, to elicit information from the witness? I know what they're the cardinal points or the essence of cross-examination. One is to test the accuracy or veracity of the evidence of the witness. For example, the claimant has called his witness to prove a case with respect to maybe ownership of land. They have stated why they feel the land is theirs, and you are the lawyer on the other side. You are for the defendant. Now, your own witness or your own client, who is the defendant, is also laying claims to the land. Now, the questions you're going to ask that claimant witness is questions that would test the accuracy of what he has said. Questions that will either confirm or show to the court that he or she is lying, or the evidence should not be it should not be accepted by the court. So the essence of cross-examination is to test the accuracy. What this witness said, is it true? Is it valid? Is it authentic? So the cross-examination questions is aimed. So you need to understand the purpose of cross-examination. One is to test the accuracy, veracity, and the credibility of the witness. Is the witness a credible witness? Is he a witness in whose evidence the court should rely in arriving at his decision? So if your questions in cross-examination does not align with the purpose of cross-examination, then you are missing the point. Now, you also the purpose of cross-examination is to also discover who that witness is. What is his position in life? From what point is he giving this evidence? Who is he? Is he a witness that's been trusted? Is he a witness of truth? Now, another essence of the cross-examination is for you to shake the credibility of the character of that witness. The witness that say, peradventure, I'm a pastor, or for example, I'm a pastor, or I'm a religious leader, and the court looks at him as someone who understands the tenets of speaking the truth, or who is being held in high esteem. in terms of saying what it is as it is. So you now begin to ask questions to shake his credibility. Is this credible? Is he a credible witness? Those questions is to shake the credibility or by injuring his character. You see questions in cross examination where someone is asking a witness, I just heard you know, you just married your fourth wife after having three failed marriages. You'll be wondering, is that part of the questions? But the essence of that question was to, show the court maybe this person. I'm not saying failed marriages is makes one bad, but it just maybe that question is posed at making the court make the person or making the court believe that that person is maybe have issues of maybe temper or cannot make a home or you just I'm just using this as an example. You see someone begin to ask questions on I'm aware that you failed your law school, for example, or I'm aware you didn't graduate from school, making the person feel, just to look at it, get the reaction of that person, or to make the person begin to know, this lawyer knows me or knows my past, and questions that will begin to injure the character of the person. Or you let the person know that I'm aware that in 1993 you were arrested for so and so. The person will begin to wonder. Those questions has to shake the credibility, to shake the to attack or shake the credibility of that witness by injuring his character. So we see questions that injure a character of a witness. That is all you see in cross examination. Now, another purpose of cross examination is for the defender, for example, because in this instance, I'm using the defendant as to run cross examination to put across his own version of the case. I've used the issue of ownership of land as an example. You are the counsel who's cross examining a witness. So through that cross examination, you're going to put to the court your own version of your own story, because you're discrediting what the witness has said. You're saying, peradventure, my client owns the land. So what you're going to put in through that cross-examination is your own version of the story, to put your own version of the story. So that is the core, the purpose, the essence of cross-examination. This purpose of cross-examination must be well understood. When you miss the point, it makes it makes you to fall off from aligning on the path of the techniques for cross-examination. Many people do not understand why there should even be a cross-examination. That is why you see people waste 1 hour asking questions that did not even achieve the purpose for which they are cross-examining. Now, let's now go to the cross of the topic of today, techniques. How do I position myself? What are the things I need to do to get my cross-examination right? How do I ask questions that will, bring out the answers I need? How do I shake the credibility of this witness? How do I let the court know that this person is lying? Which questions should I ask to bring out the truth of the juice of the case? Now we have, it's not exhaustive, but we're going to look at majorly 3 types of techniques you are to utilize during cross-examination. And over the years, it has worked. Knowing these techniques, it helps you to fashion your questions. It helps you to fashion your questions in the right way. Now, the first of the technique is what I call the probing technique. The probing technique. What does the probing technique entail? Now, you're going to ask questions to probe. So you are trying to pin the witness down to a definite account of event. Peradventure, the witness maybe is in a criminal case. I'm using these examples to bring home the point. Maybe in a criminal case, the witness has already put up the defense of alibi. I was not there. I was not around that place. I was not even around when this thing happened. Now, in a probing question, you're going to begin to pin the witness down to the fact that he was there, or he was in that vicinity, or he was in that space when the crime happened. So the essence of probing technique, as the first technique you can use in cross-examination, it is designed to elicit information from the witness by pinning him down to a definite account of event. The witness has said, I was in Medugri as at the point this thing happened. Now, your cross-examination question, or you're cross-examining the witness, you are aware that the claimant was in Lagos. You now begin to create an account. Witness, on the 15th, I'm aware you attended a wedding. And in that wedding, you wore this. Can you take a picture? This was the look, your look on that wedding. And this happened, and this happened. So the essence of that technique is for you to pin the witness down to your own account of the event. And you know what? Until you get your desired answer, you're not giving up. Yes, you're not giving up because you have an intention, which is you are yet to achieve. Now, in using the probing question technique, you use both the open questions and closed questions. Open questions. What are open questions? Open questions are questions you ask that requires the witness explaining for and all of that. But the closed question is the closed question that they a yes or a no. So you use both that this happened. You believe me? I put it to you. It is true. You see the questions where people, client lawyers ask this question. It is true that you didn't go to St. Mary's schools. It is true. They say, yes, it is true. I didn't go. You will agree with me that you visited Tunde on a Thursday off. So you agree with me. You say yes. So in using the insinuation technique, you're luring the witness, through both deductive and inductive reasoning. Look, listen, in deductive and what inductive, you're just luring the witness to what agree to what you're saying. This insinuation technique is usually used for very experienced lawyer, because if you're not well experienced and you meet a smart witness, you may not be able to elicit much, or you may end up having a back and forth with the witness, and it might piss off the judge, who might just say, "Counsel, can you round up? How many more minutes do you need?" and all of that. So when you want to use the insinuation, you must be good in using the inductive and deductive reasoning. To a point where the witness begin to expose his ignorance, and he begin to speak about the things you want to hear. Now, it also helps you to expose the fallacy in the evidence of the witness. So it's called the insinuation technique, where you lure the witness, using both inductive and deductive reasoning to elicit your answers. Now, the third one we have is called the technique of confrontation. A lot of lawyers use this, but you know what? Sometimes the confrontation technique does not really work on some witness. So when you see a witness, or when you have read the testimony, the evidence, the witness statement on oath of a witness, you begin to see the kind of person. You begin to see a lawyer. A lawyer must be able to meditate. A lawyer must be able to see beyond the papers. The work of a lawyer is not only the physical. You have to involve the mind. You develop your mind to begin to deduct or begin to see things beyond what others are saying. Now, when you have read the statement of the witness, you begin to know who is this this witness, who is he, what is this, which kind of person, what is his personality. Most of the time, when people have used this confrontation with it worked for them. Most of the time, it didn't work. You may end up spending so many hours and you did not achieve so much. But some other time, for people who are comfortable with it, who can do it so well, when they confront the witness with that confrontation technique, the witness begin to spill. In this confrontation technique, you now confront. What you do is that you confront the witness with the facts from which he cannot deny. You confront the sometimes you see people still use the word, "I put it to you." Mr. Witness, or Mr. Sir, you did not go to so place, or you did not buy the land. You did not pay so. No issue was issued to you. You confront the witness with incontrovertible facts, which he cannot deny. Now, you also, in this technique, you look at the maybe witness statement of oath of the witness, use what he has said to contradict him. At paragraph 6 and 7 of your witness statement, you made mention of, or you stated that this. Is it, am I correct to say it is true? Or I put it to you that it is not true. Rather, on so, you went so, or you did so, and so. So what you just, the major essence of the confrontation technique is to what? Contradict the facts of that witness. So in using the confrontation technique, you can combine both the probing technique and the insinuation technique to achieve what you want. So under the confrontation, you can merge the three together and what achieve the essence of your cross examination is for you to what elicit, your the evidence, the evidence you desire is to test the veracity of the witness, to test his credibility, to check his, to enjoy his character, to check his credibility. That's essential. So you elicit your own, you elicit the truth you want, and also put to that witness your own version of the story or version of the facts which you believe is true. So this technique, you need to master it. Many at times the law practice is what you grow by learning. And how do you learn? By observing, by participating. So you can start with the little, small, as you're looking at other people, you're seeing how it is done. Don't be in a hurry to leave the court. If there's trial, you just watch. I know there's some people that are so good in cross-examination. You are laughing with them and they are getting what they want. Whereby some other people, they are so poor in cross-examination that you might spend 2 hours, they might end up asking 100 questions, and I know they will not elicit up to 30% of what they want to do. Now, it's also important to know that it's not in all circumstances that cross-examination is necessary. Where the evidence of a witness is already self-contradictory, it lacks substance. You don't need a cross-examination. Yes. Where the evidence of that witness is even adverse to his own case, do you need a cross-examination? When even the evidence does not harm or does not do any harm to your own case, or when the examination it does not even do any harm to your own client, to your own the party, you don't need cross-examination. If the witness's evidence will even help you prove your case, then why do you need a cross-examination? So it's not in all circumstances that cross-examination is necessary. And you see, sometimes during cross-examination, there's some question even as the court will, say, counsel, can you please ask another question? Or when an objection is raised, the court is said sustained, and you move on. So you must, you must know when to cross-examine. And when you're cross-examining, utilize these techniques that I have, explained to you. These three techniques of probing, insinuation, and confrontation. These three techniques work beautifully. You can master it, you'll be an expert in cross-examination. And as a lawyer in litigation, if you don't know how to do cross-examination, then it will be very difficult. You might end up losing good cases because you did not do your job well. So, friends, it's been an amazing time. I just hope you learned something from today's class on how to conduct cross-examination, the techniques you need to know when it's not even necessary to conduct a cross-examination. If you're yet to subscribe to the channel, please do hit the subscribe button. Join us. Tell a friend about Lawyers Info Hub. We have wonderful content on the channel that will be very helpful to your practice, to your career goals, to your career growth, to also career development and even personal development. Please go through our channel, check out the videos. I know you enjoy them. Do take care and bye. You know what? You can always be the best. Do not be intimidated. Do not allow your present circumstance to put you down. Rise up. Be your best at all points. At any time, be your best. Do take care of yourself. Bye.